Everyone, welcome. As you can see, I am going to be speaking today on the reasonable efforts, legal mandates in dependency cases, specifically involving domestic violence. I did want to correct the cover screen, the PowerPoint first slide. I am currently the supervising judge of the Juvenile Justice Court. I spent many years as the supervisor of the Juvenile Dependency Court here in Santa Clara County, but this is my second year supervising the Justice Court, which is the delinquency court, what we call our delinquency court. So I just wanted to update you all on that latest and greatest update. So we'll go ahead and just get started. I am happy to take questions along the way, but if I find that it may endanger us getting through the slides, I might have to ask to switch to the end, but we'll just kind of play it a slide at a time. So with regard to who's with us today, we are going to do a poll, and I think that Alicia was going to make sure that you could see who's here along with me. Like I have a social worker, domestic violence advocates, great. Advocates, policymakers, legal professionals, great. And other. So welcome to everybody. Next slide, we're going to talk about here, take a poll on how much experience that you have, if you could fill in. Less than a year, it looks like, a lot of people. Then we have some long-timers like me, greater than 10 years. And then people that are 1 to 5 years. Okay, so 5 to 10 years, looks like we're kind of spread out. If you're like me, it doesn't hurt to have refreshers and updates, and if you're less than a year, I hope that some of this is helpful to you. There's a lot of learning to be done in this field, and it never ends. So the learning objectives that I have laid out today are a couple. One is to obtain a general understanding of the legal framework surrounding reasonable efforts in dependency cases. And the second is to identify the steps that child services can take during the life of the dependency case involving domestic violence, specifically with regard to domestic violence. So with regard to the legal framework, I'm going to kind of give a historical context, because I know when I first started, it was kind of, alphabet soup with all of the different acronyms and statutes. The 1974 Child Abuse Prevention Act allowed for federal funding to states to support prevention, assessment, investigation, and prosecution and treatment of child abuse and neglect. And there was a series of hearings between 1975 and 1980 that actually revealed that states were removing kids without trying to preserve them in their families. And they weren't providing adequate services with efforts to reunify the children. So because this is a super, super invasive state action, where the state goes into the home and tells a parent that they are not capable or fit of taking care of their own child, Congress, of course, felt like more had to be done. Some people equate the dependency process ultimately, which can result in the termination of parental rights, as the civil death penalty. So it's a very, very invasive state action, a very powerful state action, and in many cases, a very confidential state action. So more oversight was desired. And not surprisingly, there is a disproportionate impact on families and children of color, and these laws tend to have a disproportionate impact on our least resourced families, our poorest families, our more marginalized families, disenfranchised families, uneducated families. And so the legislative process kicked in and said that we had to do better. It was during these hearings that it was also found that child welfare agencies were failing to create case plans for foster children, which unnecessarily prolonged their time in foster care. And it was during that time that we heard the phrase foster care drift, which was the movement from one foster home to another for years and years with no efforts for permanency. Simultaneously, Congress learned from research conducted in the 60s and the 70s that with the provisions, the right provisions, the correct services, that a greater number of families could actually be preserved and safely reunited, kids safely reunited with their parents. And I think that just as a commentary that we see today a significant reduction in foster care placement because of some of that research and some of these efforts that were occurring during this era. We know that in many of our largest cities like Chicago, New York, and LA, foster care populations have actually fallen to half of what they were during this period. In 1980, the Adoptions Assistance and Child Welfare Act was created, and this act sought to encourage states to examine in-home services and to try to keep families together whenever feasible. Removal was still in the legislative scheme, of course, but keeping families together was encouraged and elevated. Under this statute, the nation's juvenile and family courts actually became responsible for the oversight of the agency interventions at critical points in the juvenile dependency process. Removal required a finding that the continuation in the home was contrary to the child's welfare, and that there also had to be a finding around adequate services to reunify. In 1997, Congress added additional requirements through the Adoption and Safe Families Act, also known as AFSA. And this act focused again on child safety, but one, it shortened the period of time that reunification services could be provided to the family. Two, it did create bypass grounds. And three, it created a case review system and instituted adoption incentives. The new law also added a third criteria for judges, whether the agency was making reasonable efforts to make and finalize alternate permanent plans for the child in a timely fashion. So at the end of the day, we had 3 reasonable effort findings now that the court was responsible for. 1 at the time of removal, 2 at the reunification hearings, and then 3, timely permanency. The question was, were reasonable efforts made, and did the agency fail, or did the agency fail to make these reasonable efforts? This was the $65,000 question, if, so to speak. Because if the agency failed, then the agency received no federal funding for the case while the child was in foster care and until the failure to provide reasonable efforts was remedied, which meant that the local government then had to pay the cost of the foster care placement and case management out of general funds. It's important to note that this is an uncapped government price tag. In recent times, it's been anywhere between $6 to $8 billion a year of Title IV-E reimbursement monies to the states. And there could be an entire seminar on child welfare finance reform and child welfare finance. I just want to make us all aware that Title IV-E supports case management and foster placement, and Title IV-B is the monies that are focused on family preservation. And they're woefully, the family preservation pie is much, 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 much smaller than the removal Title IV-E pie. And as recently as last year, we had the first Families Act that was looking to try to reestablish the family preservation monies at a higher rate, and it did not make its way through Congress, but I know that it's a very important discussion. Federal law requires that a case is handled in several particular ways, a dependency case or a child welfare case. I know that different states may have different names. There's a federal audit that the feds do for each of our agencies to ensure compliance with these very particular findings. And, of course, a lack of compliance. The audit, if the audit shows a lack of compliance, we lose money. California has lost millions of dollars through these audits, and that's why judges are trained, clerks are trained, child welfare is trained to make sure we have the correct findings and the correct strategies for these cases. So just kind of in a nutshell, and so we kind of have a context for everything later. First, the court has to oversee the services that were put into place to prevent removal. If removal is the choice and that we have to do the removal, then we need to oversee the case plan. Should be least restrictive, most family-like setting in close proximity to the parent's home, which is consistent with the best interest and special needs of the minor. The case plan is an integral element of the reasonable efforts requirement. The case plan must spell out why the child was removed, as well as the goals and services with which will be provided to enable the parent to correct problems that led to the removal. The case plan must be developed jointly with the parent or guardian, and each plan must specifically include a description of the services offered and provided to prevent the removal of the child from the home and to reunify the family. And third, the agency must provide substantial information and assistance to the parent before the parent's rights are altered or lost. So reasons for state intervention, what have to be laid out. What the parent has to do to get the child back has to be laid out, and services and referrals and meaningful ways to get the child back to fix the problems must be availed. The state simply cannot take children and then not make a way back. And that is why it is so important for us to understand what kind of case we are dealing with. And if we are dealing with a domestic violence case, it's very important for us to make sure we have that early screening, that appropriate assessment for the multi-layered approach that must be taken when we focus on the family that is in the throes of domestic violence. I wanted to go ahead and show, and I know some of you who have been participating in the series may have already seen this video, but I think that the story of Rachel helps us to center ourselves and understand that we're not dealing just with a case number, but with a real family. So I'm going to go ahead and Alicia will make this happen now. That's a really powerful reminder of the real impact of a victim being so courageous and calling for help and what that means. Certainly, probably most victims try to think things through and know that the enormity of the of what is going to happen once that call is made, and that may be one of the myths that we have to really dispel about why victims don't call. Look at how much was there in that one vignette. Historically, there has been a long-standing tension between domestic violence advocates and child welfare professionals, and I know that maybe today it's not as significant as it used to be, But I know that before this county involved itself in the Green Book work in 1999 and 2000 through 2006, that there was a reluctance to learn from one another and to use tools and interventions in tandem to protect victims and their children. I think that historically there's been very siloed approaches, and there's been a mistrust, one side viewing the other as malintended, baby snatchers on one side and mothers who don't protect on the other side. I think that we've come a long way, and that there is a lot more collaborative work, certainly being supported by the National Council, and there's the entire compendium called the Green Book, which is effective interventions in cases involving child maltreatment and domestic violence, which has 67 recommendations on how a jurisdiction can begin to work together collaboratively with DV advocates and law enforcement, child welfare, first 5 CBOs, community-based organizations that focus on the needs of children. So there's some real good, solid work. There's good research. And I think that we are starting to understand that if the mother is protected, and in this case today I will be using mother as the protective parent, although we certainly do see a number of cases where fathers are the victims. For ease of discussion today, I will use mothers, that where mothers are protected and safe, then children can be protected and safe. I wanted to reiterate that cases that enter the child welfare system in Santa Clara County are initially brought to the attention of the agency, generally not because of domestic violence these days. We don't really have petitions being filed solely because of domestic violence. I think the Green Book really helped us sort out, and then case law in the last 10 to 15 years have helped us sort out that cases that are solely alleging a failure to protect for domestic violence are very few and far between. Our cases usually come in with drug overtones, drug use, maybe a baby was born, positive toxicity, under the influence charges, neglect, mostly neglect, police response to neglect that may have included family violence, domestic violence. But the straight DV case is very, very rare. But it's very important for that reason to understand the overlap phenomena between child maltreatment and domestic violence. And we do have research that states that anywhere from 40 to 70% of cases that involve child maltreatment also involve domestic violence. Similarly, if they involve domestic violence, they also involve child maltreatment. It's important for us to make sure and tease all of this out, because domestic violence is very complex, and there is no one-size-fits-all case, and there's no one-size-fits-all solution. This really requires us to do and be our best when it comes to social work, substance abuse interventions, advocacy, legal work. Domestic violence crosses all socioeconomic lines. Perpetrators of domestic violence can be male or female, and this is true for domestic violence victims. In the overwhelming majority of reported cases, however, women are victims of domestic violence and men are the perpetrators. And this is mirrored in the majority of the cases that come under the jurisdiction here in Santa Clara County. And again, for this reason, I will refer to victims as, throughout this webinar, for the sake of brevity, as women. Now, although there are many common threads for individuals who have experienced domestic violence, each individual must be recognized as unique and their experience as being unique. When assessing risk factors, emotional impact, individual context is critical. Context should include cultural background, non-ethnic cultural impacts such as gang involvement, poverty impacts, religious beliefs, abuse history, standing in the community, immigration status, mental health, addiction, professional backgrounds, and their own histories of childhood trauma. One of the items that I wanted to share with you is that here in Santa Clara County, we do have what's called a domestic violence intervention collaborative. And I did want to just speak for another minute, though, about Rachel's video so that we can continue to keep that in mind. Rachel called the police. She called the police, and then in that last part of the segment, she was labeled by the social worker as uncooperative. And that was, of course, after a few days of overwhelm and demands and just a woman who ended up having absolutely nothing more to give. But I wanted us to remember that she called, and that is something that I do see, is when women or victims reach out for help. Sometimes, sadly, because the court and these law enforcement agencies and child welfare, CPS, that is a law enforcement agency. The only response that we have sometimes is a law enforcement response. And so I often say that the courthouse door has become the last social safety net. So we have to be very, very careful about examining how cases came to our courthouse door. And we have to remember that Rachel is every woman. She is the mother, partner, provider, organizer, healer, rock of her family. And that all doesn't stop because of abuse. Rachel has to navigate life, which continues for her and her kids even after she summons the courage to call for help. And this film helps people like me in my role to remember what the people I make decisions about are really going through and how and why they make the decisions that they make. Staying client and survivor-centered is critical to our work. And I often say that the marriage between the court system and these huge social problems, which are also law enforcement problems in their sorting out, but a lot of it is also problems of we saw the eviction that was coming in, the help that she may have needed with child care. Certainly resources were needed. That imperfect marriage is not very well handled here in our court systems. So I just want us to stay with this notion that we're not exactly the right match for 100% for a fix for this. We may be able to swoop in and make sure everyone is safe in the beginning. We're not always so good at what we do next. And I really want us to make sure that we stay in our work, in our day-to-day work, survivor-centered and client-centered and child-centered, because we actually have the unfortunate truth of creating more harm if we're not very, very, very careful. So I will go ahead and go back to our domestic violence intervention collaboration. Here in Santa Clara County, there's a nonprofit. It's a court-based nonprofit, meaning that it's at the courthouse site. And it's called the Domestic Violence Intervention Collaborative, and it's run by a woman named Nancy Marshall, who you may have heard of or heard from. And it's really our effort at creating an infrastructure for systems to address this pervasive, overlapping family violence, substance abuse, child neglect, child abuse phenomena that we see in the child welfare courts. And what the Domestic Violence Intervention Collaborative does is it actually is a hands-on, co-located feature of our dependency court. They see the majority of our clients. They actually go through the petitions before the detention hearing. We have, standing orders that allows that. They see a majority of the clients before disposition. So if they don't see them at detention or the jurisdiction hearing, they'll see them at disposition, which is often at the same time as the jurisdiction hearing. Sometimes detention hearings are also called initial hearings. Those are the first hearings that we have at the courthouse after the child is removed within 48 hours. Majority of our clientele is Hispanic. A majority are also involved with substance abuse. Services include in-court support, so these are domestic violence advocates, trained advocates, help with restraining orders, help with victim witness, setting up case numbers, setting up applications for access to money for mental health therapy, alarm systems, maybe even to move the family. Victim witness has a whole host of services. Counseling, again, the DV support groups we have that we run here in Santa Clara County are also run by the Domestic Violence Intervention Collaboration. They participate at team decision-making meetings, family team meetings, our family wellness court, which is now our dependency wellness court, and any of the other specialty courts that they need to be at. So that's our domestic violence intervention collaboration at the courthouse. And I wanted to just point that out because when you're looking at the reasonable efforts in dependency cases for domestic violence, it's very, very important that you understand that those reasonable efforts start pre-removal. So we need to find that as many services as possible were offered to that family before we even thought of removing that child. So that means we want to make sure that we're looking very carefully at not just what efforts were made to prevent removal. Then we're also looking, again, just to overview, returning the child home, and then the permanency. That was the three areas that I had spoken of earlier, but I just kind of wanted us to refocus on those three areas. Reasonable efforts to prevent removal, reasonable efforts to return the child home, and then reasonable efforts to achieve permanency. And of course we have the ICWA, the Indian Child Welfare Act, which actually requires active efforts. And if you are going to remove an Indian child from the home, active efforts must be made to prevent it, and active efforts must be developed to find an Indian family. Now, I wanted to move over to the, well, before I talk about that, I'm sorry, I have a little bit more to say on this other slide. In a household with domestic violence, it's one of the things that's why it's so important to look at the prevention to remove is because depending on the age of the child, there are different approaches that are in order. Certainly, the younger the child, the more important it is to keep that child safe if the victim is unable to. I did want to turn for a moment to Judge Edwards' book. It's called Reasonable Efforts, A Judicial Perspective, and he wrote this book, and it's really a distillation of all the law on reasonable efforts. And he said this about domestic violence cases specifically. A child's exposure to domestic violence in the home can result in state intervention on behalf of that child. In fact, a substantial portion of CPS caseloads involve domestic violence. Domestic violence cases typically involve one parent inflicting violence upon the other and are often accompanied by parental substance abuse, dirty home conditions, mental health problems, sometimes poverty and homelessness. Commentators note that while social workers may identify substance abuse or mental health issues as a justification for removing the child, the issue of domestic violence should not be overlooked, whether it is identified at the outset or during the pendency of the case. The legal issues that the court must decide include whether the agency provided reasonable efforts to prevent the removal of the children, as I have indicated. Then he also points to the Nicholson case, which we'll go ahead and look at right now. The Nicholson case is out of New York, and I would like to give you a moment to read this slide. Go ahead and take a moment. The most important case regarding domestic violence, child protection, and reasonable efforts is this case, where a federal court judge in New York City held that the state violated the mother's constitutional rights by removing her children after she was victimized by domestic violence. The court made clear that social workers have a responsibility to the victim of violence as well as to the child in order to prevent removal of the child. To satisfy the reasonable efforts requirement, the court suggested that the social worker explore options such as removal of the abuser, assist the victim to secure a restraining order, or placement of the victim and child in a safe environment. The fact that a parent is the victim of domestic violence is insufficient reason to remove a child. Findings by the Nicholson court are outlined here. Social services regularly alleged and indicated a neglect against battered mothers, which is a very common allegation. Social services in New York rarely held abusers accountable. Social services failed to offer adequate services to mothers before separating them or removing their children. New York Social Services regularly separates battered mothers and children unnecessarily. And New York Social Services failed to adequately train its employees regarding domestic violence. New York Services written policies provide insufficient and inappropriate guidance to employees. These were the court findings. And after the Nicholson case, social service practice in New York changed significantly. The New York courts recognized the obligation upon child welfare agencies to provide services to prevent removal, and the court's obligation to review agency actions to determine whether or not the agency fulfilled its legal obligations. Further, subsequent New York case law clarified the agency's responsibility to provide services to enable a parent to reunify with the child. One appellate case noted that the agency efforts should help the parent so as to render the parent capable of caring for the child. These services may include assistance with housing, employment, counseling, medical care, and psychiatric treatment. I think really it's safe to say that the Nicholson case really transformed the landscape, and it really fortified us with our Green Book work, which, as you see, was around the same time. I know that my work with police agencies and with child welfare agencies was also transformed, and it was very much more likely that protective custody warrants are being sought than ever before by both police agencies and by social services. Police agencies have been and were sued around this time for failing to address these issues and to treat them as the law enforcement matters they were, instead of simply as some sort of family matter that was her fault in the first place. And I think that the Nicholson case really helped to transform the landscape, as you can see. In addition to finding that the social services violated Ms. Nicholson's constitutional rights by removing the children, it also found social services just failed and weren't trained. And one of the things that I know our jurisdiction has done is we are very much training folks on domestic violence, and there is a domestic violence social workers unit for the more lethal cases. Even though a lot of our cases involve domestic violence, there are some that have more significant features of domestic violence, and those cases do go to the domestic violence unit for the social workers. So what does a reasonable efforts look like to prevent removal? And this is the big question because it isn't outlined in the federal statutes that we went over at the top of this webinar. Really, states were left to figure it out, as is often done with federal and state statutes. The overarching law is presented, and then we are left to sort that out. And honestly, I have to tell you that it can differ from jurisdiction to jurisdiction because that reasonableness requirement, it is a reasonableness requirement. We can't expect a rural agency to provide something that a city agency could provide for obvious reasons. So judges must find that child welfare made reasonable efforts to prevent removal, and if not, they can lose the Title 4E reimbursement. So how do I make that decision? What goes into that? Well, first of all, as I said, we need to screen, and screening helps us identify what's what and put in the right services. I mean, if it's just a drug case, then the right services involve drug treatment. If it's a physical abuse case, the right services most likely will center around separating the parent and getting the parent the intervention needed to keep that child safe. If it's a mental health case, then obviously you need to sort that out and see if there are services that can prevent removal. But really, it's the first step here, and because there's a huge overlap, it's the first step in keeping overlap of child abuse and DV. It's also the first step in making sure that we're really keeping this child safe. And we have to remember that a parent presenting with mental health issues or substance abuse issues could very well be dealing with the trauma of domestic violence. And as I read earlier, that certainly is the case here in Santa Clara County. As I said, we screen to keep kids safe, and we screen to help prevent removal. We also screen to help us understand behavior of the parent, behavior of the father, behavior of the mother. We need to make sure that we have people are trained. As I said, we have the detention packet available for the Domestic Violence Intervention Collaborative. We have trained social workers we have trained judges. Judges are trained to understand lethality, understand the overlap phenomena. If I have a child abuse case, a physical abuse case, or a sexual abuse case, I think that is definitely a red flag for me to have the case screened for domestic violence. When I was a prosecutor, my first legal job as a district attorney, my DV cases were the whole 9 yards. It was sex abuse, child abuse, and domestic violence. So I think I was getting the cases with the 90% overlap. Those were the he hurt everybody cases. And when I see a case that comes in on one featured abuse, I often believe it's very essential to screen for domestic violence. So then we start looking at protective capacities and protective factors, because this could prevent removal. And it's very common for me to ask whether or not the protective or the non-offending parent was willing to engage in informal services, because it's often true that she is already practicing a 24/7 expertise in keeping her child safe. That's what victims of domestic violence do, is they're constantly gauging the temperature in the house. They're constantly figuring out how to keep people safe. So we really do want the agency to assess the protective capacity of the non-offending parent. We also want the agency to consider the age of the child, the developmental stage, gender, type of frequency of the violence, and the positive relationship with other adults and personality traits. Is this a closed family system where nobody's getting in, or is this a system where the children are actually going to school, there are grandparents around, the mother may already have people in counseling? What kind of family system is this? So we really want to assess the capacity. And who called? If she calls, then we're for sure knowing already out of the gate that she's protective. There's a study out of MIT from 2007, and that was a Joseph Doyle study saying that children assigned to investigators with higher removal rates are more likely to be placed in foster care and have higher delinquency rates, teen birth rates, and lower earnings. Results suggest that children on the margin of placement tend to have better outcomes when they remain at home, especially for older children. Removing a child from a family, as you all know, if you're on the call, very likely, should be the very last resort, because family separation can actually cause more trauma, and Stanford research says it actually can cause the long-term trauma, the long-term cortisol production in a child versus the initial trauma, which was either the witnessing of domestic violence or any sort of neglect or abuse in the home. So we have to be very, very careful about assessing why we're removing and how we're removing, and be quick not to remove. Now, if the child is removed, the agency must demonstrate efforts to get the child home. First, the agency must first demonstrate reasonable efforts to prevent removal, and then by the time that they get to the courthouse within that 48 hours, I want to know what was even done in that 48 hours. So I have to make a finding that continuing the child in the home is contrary to the child's welfare. So at this point, I'm going to be inquiring about efforts to get the child home, even if there was that removal at the beginning, kind of a removal to sort things out. Well, how can we get the child home? And again, was there reasonable efforts? So I asked a lot of questions at the first hearing. Why was the child removed? And if there is if we do know that for sure that there was a rationale for removal, and it's a domestic violence case, there's 3 potential scenarios for the removal. So first, I'm determining the efforts, and then I'm looking at these 3 potential scenarios. The first one being was that the child was directly abused by the batterer, which is often a failure to protect allegation, that the mother failed to protect the child from being abused. The second possible scenario is the child was directly abused by the victim, by the mother, by the non-offending parent in the domestic violence language. Third, that the child was removed due to mere exposure of domestic violence in the home. In this county and in case law, we know that merely witnessing is not enough for a removal. We've agreed as stakeholders in our teams that it's not enough for removal. But it is often, it needs to be analyzed very closely with age, special needs, numbers of referrals, danger to the child, future danger, risk of danger. It's usually not a stand-alone, so there's usually other factors that are considered. The types of efforts provided in each of these scenarios may be different given the identity of the primary perpetrator and the presence or absence of a secondary perpetrator and the nature of harm to the child. So those are the three things that the court's looking at. Was the child directly abused in the way when there was a fight, hit accidentally? Was the child purposely abused, directly assaulted by the perpetrator? Or is it just this kind of emotional abuse, the exposure that is occurring, and what can we do to prevent the need to remove that child in these three scenarios? So here we have the direct questions. Did the agency make reasonable efforts to prevent removal? And at these initial hearings, I want to just caution us to take time. A lot of us are coming into initial hearings and we are spending 5 minutes. But we need to take time because this is the gatekeeping portion of the hearing. Once a child gets detained, the ball is rolling forward, and it's very, very hard to get the ball to roll backwards. So if your jurisdiction is not giving these detention hearings time, I would urge you to ask to know that it's a best practice. We try to, 30 minutes is a good time to allot. Now, do we need the whole 30 minutes? No. But you don't want to pile up your detention hearings with a morning calendar that has 30 other cases on it. So for the judge to ascertain whether or not the judge asks about investigation, how did the family come to the attention? Is it a hotline report, police referral? How did the caseworker determine there was domestic violence? More questions involve history, past history of domestic violence. Was there injuries to the child? Things that we've already discussed today. Further inquiry is the judge should inquire about how the agency sought to address that domestic violence prior to removal. Why can't the child stay home? That is a question I ask at the initial hearing often. Did the adult victim have strategies to keep the child safe? What were those strategies? Why weren't they effective? Did the caseworker consult with a DV advocate or expert? Did the caseworker consult with a probation officer or parole officer of the perpetrator? Did the caseworker assess the case to determine the likelihood of future violence? Why can't the child go home safely? Can we give the adult victim assistance to keep her and her child safe together? Can we have them move? Can we have him move? Is there a safety plan that we can help her with? When I first got to dependency court, I would be told at these hearings, oh, she doesn't have a safety plan. But then, they were expecting her to make a safety plan. So then we started having the DV advocates at the courthouse helping make safety plans, develop a meaningful safety plan. So I could ask, is there a meaningful safety plan? And if they said yes, then we could talk about keeping the child home. Help the victim find a family member to stay with temporarily. Give the adult victim income to help her live independently. Now, these are, of course, wish lists, but I'm telling you, abundance is available in your community if you start articulating what you need, and certainly there are victim witness services. Increase police presence around the home. Enlist the support of community entities such as churches, schools, neighborhood organizations. I had one Samoan pastor come to court and give the victim a cell phone and agree to have somebody at the house 3 times a week, so that the 8 children could remain in the home. The department wanted to remove the children because he kept coming over and she wasn't calling 911. Well, she didn't have a phone to call. So we have to be very creative because having 8 Samoan children in the children's shelter does more harm, I would argue. Reasonable efforts, providing the adult with legal assistance. What about an emergency protective order? I gave you all a copy of the California statute that allows 24/7 emergency protective orders. The police can call from the home and get a kick-out order right there on the spot and get a protective order 300 yards stay away. Was that offered? Can we help the victim, again, get into a shelter if necessary? And are there services that she needs? Drug and alcohol. Can we get the child and the mother to a rehab, to a residential treatment that allows for children? Does she have a DV advocate? Can we secure counseling for her? Crisis nursery and other daycare services, transportation. One of the there are a couple of bright lines in reasonable efforts. One of them is transportation and the other is visitation. Just so everyone knows, those are pretty bright lines. If you're not offering those two services in a meaningful way, you're very likely not to be offering reunification. Of course, interpreters are mandated by law. You cannot take people's children without giving them language services. And then, of course, looking at immigration assistance, family support court, looking at child support and spousal support. Remove the batterer, not the children. That's something that came out of the Green Book. The agency must address and consider removing the batterer from the home, either voluntarily or through court order. It's very common for them to leave the home. It's also uncommon, but I do have situations where he will leave and allow the family to stay together with the appropriate restraining orders. So the summary for reasonable efforts, this is to prevent removal. Remember this. Screen, identify alleged harm, provide appropriate services, assess the non-offending parent's protective capacity, provide services that ensures that the child and non-offending parent can be safe. If the agency has failed, the court can hold the case over for 24 hours to make sure things get into place, and then have another hearing and see if those kids can go home. Judge is the gatekeeper and should closely scrutinize the ability of this parent if she has the appropriate help. Remember that a mother who feels protected and safe can safely protect her children. That is what I have learned through both experience over the last 20 years and through training. If the child has to be removed, we have to look at reasonable efforts to get the child home. This is also one of the three big oversight judicial mandates. So getting the child home. If, despite an agency's reasonable efforts to not remove, then we have to look at getting that child home, and the agency should continually assess if the child can be returned home, and the court will always examine the agency's efforts, and the case plans, as I indicated earlier, are an integral effort, an integral key to knowing whether or not reasonable efforts have been offered. And remember, at the end of the day, this is what the case plan is, what's going to be scrutinized at that 12-month hearing or that permanency hearing. Did the services, were they enough of a match to ameliorate the conditions which caused that child to come into care? And so that's why it's very important that the case plan match the problems that were brought in. So you want to have things like individual and group counseling for the adult and the child. You want to have a case plan that involves assistance with independent housing if the family decides not to, if the parents, the couple decides not to get together, not to be together. You want to make sure that the parent, the protective parent, the parent that you want to return children to can live independently. Look at employment and economic advocacy, transitional living. You want to have a robust visitation with step down, which means if the parent is doing what they need to do, you want to step down and allow unsupervised and overnights when appropriate. And of course, the legal assistance that I mentioned around immigration, child support, spousal support, maybe even divorce court. And then the case plan for the batterer also needs to be very specific, and we'll talk more about that in a moment. Any of the underlying issues must also be addressed: substance abuse, mental health, literacy issues. You want to make sure that there's a DV advocate and a parent or a parent partner, somebody who is specifically assigned to the parent to help them be successful. We have parent mentors here in Santa Clara County. We often partner our moms with mothers who have already gone through the system. We need to make sure that this case plan is detailed and robust so that we can get the child home. Here are the two scenarios that we often see. One is that the victim chooses to stay in the relationship and the perpetrator chooses to stay in the relationship. And the other is that the couple chooses to separate. And those are the two scenarios and the two different case plans that may be necessary for us to set up. Now, obviously, different cultures and different traditions will cause these decisions. We can't analyze them and we can't judge them. We can't tell people to leave their husbands or boyfriends or long-term partners. That's really not our place. In fact, there have been lawsuits around that in this county when social workers said, if you leave him, I'll give you your children back. For some families, that's an untenable request, and they often, even if they do seem to quote-unquote cooperate, they will often be driven underground, and then we just end up compounding all of the dysfunction. Here in Santa Clara County, we did have an organization called Mi Familia, which didn't do couples counseling for domestic violence couples, but they did have a family night where they were supervised and dinner was served, and there was an acknowledgement of the family importance, and that was called Mi Familia. We do have client-centered services. Even our domestic violence agencies have recognized that if her primary concern is that he needs a job, which it often can be, then people are really starting to go the extra mile to make sure that families figure out how they can be safe together. And I know I was very judgmental of all of this when I first saw it, but I realized that all I do when I don't look at what families need is I drive them underground. I make them liars. I make them sneak. And I make everybody much more unsafe. So we just have to start really looking at this in the eye, with the lens of Rachel's story. And we need to order services that are available, accessible, and meaning that their cost can't be prohibitive, their proximity can't be prohibitive, the time of day can't be prohibitive. We have to have services provided by trained folks, trauma-informed folks, have to be tied to an identified need, safe, useful, culturally and linguistically appropriate. Inappropriate services are listed here for DV families, joint case plans, couples counseling or family therapy. Anger management is not appropriate. Visitation arrangements that endanger the mother or the child, substance abuse or mental health treatment that doesn't also address trauma of DV, or unnecessary classes or services. If you have boilerplate language that doesn't belong in the orders, then pull them out, because what we want is we want to be effective in our approach, and we want to get that to the core of the issues in a very compassionate way that also holds people accountable. Here we have DV support groups that are very effective. We do mandate the DV support groups. We have found that DV services can be successful when they are strength-based, trauma-informed, non-blaming, and ones that are geared to help the victims recognize what constitutes domestic violence. I authored a book called Family Drug Courts, and I have a chapter in there on domestic violence. And Kimberly was one of the mothers that successfully graduated from our Family Wellness Court and became a parent mentor. And in this book, she says that even though domestic violence was not the reason my daughters were removed from me, I was referred to a women's domestic violence support group. I remember the first day I attended because it was the first time I had so many moments of clarity. That day I knew I wasn't the only one, that there were others who had experienced the same craziness. I learned that I had not been the cause of this unhappiness, nor did I ask for it, or deserve to be treated the way I had been by him. The abuses that described domestic violence finally explained the behaviors that I had experienced. I would describe certain behaviors and, to my surprise, find that it fell squarely in the category of DV. Looking back, I can tell you that even while we were going through the list of behaviors, I was still minimizing. Oh, the freedom that my mind and soul experienced was so phenomenal. I felt so empowered to know that I had options, that there were ways to get through the web of lies. I wanted to know more. The empowerment that I felt was amazing. So, with regard to, let me see, perpetrators and services, sorry to skip so quickly away from Kimberly's reflection, but I'm running out of time. So we also want to have perpetrators and services, the specific services. We want to make sure that if you can do DV assessments to figure out where on the continuum of domestic violence this perpetrator falls, please do that. We do that here. And that helps us determine the level of lethality and possible interventions, especially if the couple wants to stay together. And because visitation with children is mandated by law, unless there is a finding of detriment. And again, remember that visitation with the parent is a bright line of reasonable efforts. So we can never not order visitation with the perpetrator unless there's a finding of detriment. We also commonly order the 52-week batterer treatment classes or the 52-week parenting without violence classes. Many child welfare cases, perpetrators are invisible. Engage them, find their families, because they can be placements if they can keep children safe. Perpetrators should have separate case plans, separate counsel, and perpetrators' case plans definitely should focus on minimizing risk of exposure of DV to children. Here are a list of services for the perpetrator. There's also a handout from NCJ, SCJ on holding the batterer accountable and different services that can be developed for perpetrators. And then, of course, the children. The children need their own separate interventions. We want to make sure that children are heard, that they're considered, that the trauma is addressed. We have found that group counseling for children in battered homes has been very effective because children often feel isolated and like they're the only ones. But in fact, when they get around other kids and they start to share their stories, it has really helped with resiliency. We want to make sure that any learning issues that have been impacted by trauma and domestic violence are addressed, keep them in their same schools. We see a lot of kids from homes of domestic violence later involved in the juvenile justice system. If they're foster kids, make sure that you address them as the dual status kids that they are, and don't automatically concede that they should penetrate further into juvenile justice systems. They should be treated differently. Talk to your judges about that. Review. Make sure that after the disposition, you have a 45-day case plan review. I don't want this case to be examined in 6 months and you haven't even had services put into place yet. Remember that we're holding the agency accountable. We can't hold the family accountable if the agency hasn't done its job. Certainly, if the family has decided not to participate when all ways were made, then that's another decision for the judge. But what I'm supposed to do is I'm supposed to make sure that these efforts are made by the agency. We hold all the cards, so it doesn't do us any good, either ethically or legally, to keep all the cards to ourselves. We want these families to be restored. we know that outcomes for foster children are very poor if they're raised in our systems. There's other considerations for substance abuse. Sometimes there's coercion and manipulation through the use of substance abuse and batterers. In our family wellness court, which focuses on drug treatment and mental health, 85% of the women experience domestic violence. It's just a whole different level, a much more complex, detailed level of services that have to be delivered and considered. Then reasonable efforts for permanency, to achieve permanency. If we can't reunite the child, we have to make sure that we are looking at the whole time whether or not this child was in a permanent place, a place that would keep the child forever if the parent could not reunite. Here, if it's a grandparent, we look to guardianships as well as adoptions. We don't force families who feel ethically or that their traditions will be violated if they terminate parental rights. We don't force kids to move out of those homes. We think those are forever homes, and we support those homes. We want to make sure that if we are able to reunify the family, and I don't have a slide for this, but prior to the permanent removal, if we decide we can reunify the family at that hearing, and the family had separated, then we're going to follow that case probably for about a year to continue oversight to ensure stability and support for that autonomous living for that parent, including looking and making sure we've helped her with the immigration issues and the child support issues and that she's clean and sober. If the family unites, if the father is reintegrated back into the home, we want to ensure a slow reintegration. We want to make sure it's post-domestic violence courses. Everyone's clean and sober. We have community handoff supports like to 12-step community support groups, father support groups, victim support groups. And we want to make sure that that family system is now open. It is no longer a closed family system. If we are looking at keeping the child out of the house, we are looking to safe, violence-free environments from day one that can make a long-term commitment. We want to make sure that there's visitation with siblings if the kids are separated. And if the kids are not in permanent places, we always want to be looking at all those hearings, the subsequent hearings on whether or not it's appropriate to file a change of circumstances to get the children home again. With regard to judicial leadership, the National Council of Family and Juvenile Court Judges has approximately 2,000 members. Being a judge in this area of the law, we don't exist in a vacuum, and so our 2,000 members include social workers, attorneys. We meet regularly. We're trained regularly. We all are endeavoring to use best practices based on science, based on adolescent brain development, early childhood brain development, 0 to 5, trauma-informed, gender-specific, culturally competent, all those buzzwords that are true. I'm sorry that they're buzzwords and cliche, but they're true. We really endeavor to be doing no more harm to these families. The families that end up before us are the most vulnerable populations. They're largely the populations of color, African American, Native American, Latino, both in the Child Welfare Court, the Juvenile Justice Court. Judges have to be engaged in the community. We're in a unique role by law. We are supposed to develop resources. We can't order parents to do things that don't exist, like attend drug treatment. When I first started the Family Wellness Court here in Santa Clara County, the waiting list for treatment was 4 months. Well, here in California, you lose your baby in 6 months. So we had to get more treatment for mothers so that they weren't already pregnant by the time they got to their treatment in 4 months. And we did. And we got our assessments within a week, and we got placements within 30 days. And that's the kind of thing that judges have to do. We have to get off the bench, and that's the kind of thing that the National Council has really instilled in us, that we need to exercise our leadership We are in charge of agency oversight. If we want to create collaborations that are children and youth-centered and not bureaucracy-centered, we need to have meetings. We need to eliminate bureaucracy. We need to build bridges and take down barriers. And we need to take our job very seriously, which is to protect children and to make sure that families can become whole with the right help. And sometimes that causes us to understand a whole host of history, of development, of trauma, the effects of all of this on a human being, and it makes us even more keen to do our reforms, and it makes us even more responsible to focus on the healing of families and understanding the impact of domestic violence on children, on mothers, on fathers. So I will leave you with this last slide, which talks about where to get more help, more training. Thank you for listening. We do have 15 minutes. I think this is over at 12:30, so I'm able to take questions.
Hi, Judge Lucero. Elizabeth has typed a few questions in the presenter chat.
Okay, where? Oh, okay. Okay. Can you share more information? Okay. It's been active probably 10, 15 years. There are, I believe, last I knew, there were 3 or 4 full-time employees, or maybe 3.5. They have a board of directors. They do get funding from DFCS. That's our social services agency. And then they get private funding. The caseload, right now there are 1,300 kids. There are 3 judges. 200 of those kids are non-minor dependent youth. There are a total of 3,000 kids under the jurisdiction of the agency, but some of those are informal services. What should the agency do if there is no law enforcement to enforce protective orders? Well, you know, that warrants a discussion with law enforcement, and I think that your judge and your agency director can talk to law enforcement. Law enforcement attorneys, city attorneys also should be a good ear, because if they're not enforcing protective orders, there are lawsuits where police agencies are sued for not enforcing protective orders. So they have a lot of reasons to want to enforce them. I'm sure that if you unpacked this question, you're going to probably lead to other questions, but I would definitely request a meeting and ask that the orders be enforced, because judges can enforce these orders. How can you amend an order by a judge that puts child and mother in danger? If it's in the dependency court, it depends on who. So Lorena, I'm not sure who Lorena is, and under what context you're asking. Maybe I can get more clarification. What is the name of the book? So I had 2 books that I referred to: Reasonable Efforts, A Judicial Perspective by Judge Len Edwards, and then my book, The Family Drug Courts, An Innovation of Transformation. That's by me, Katherine Lucero. Is there any other questions?
I am just waiting for a couple of people to finish typing.
Okay. Okay, so I'm seeing chat questions.
Okay, great. If you want to just take it away.
I haven't seen the Tracy Thurman story, but I will, because it looks good. The law does limit the time that parents have to make changes, and if the child can't be safely returned, the law does have permanency hearing. Do I think the parent should have more time? I think it depends. I mean, here in California, we do have more time for incarcerated parents. If a child is not adopted or put into a permanent plan and they're hitting 10, 11, 12, I think there should be more time through a change of circumstances. I think permanency is really important for children and that children can't wait for their parents to get better. So I think 12 to 18 months is a good, solid amount of time for people to get on track. And if they can't, I think that children need permanency. So I think it depends. I'm sorry to be so legalistic, but I think stability for a child is really important. But I think 6 months of fast track here in California for addiction is probably not the best practice. But I also think that children under 3 need that stability, and unfortunately, babies, that formative time, need good, stable homes that aren't chaotic. So that's my answer to that. We do have good CASA. Our child advocate program is fabulous, and they do carry a large caseload. Last I heard, it was around 100 of our kids, which I know doesn't sound like a lot when we have 1,300 kids, maybe 1,100 kids in care, but I know they're constantly growing their numbers and staying with the kids forever. What are some ideal services to support victims? I think the victim support group is great, victim advocates, legal help beyond dependency, and I'm talking about family court, I'm talking about immigration, I'm talking about employment or eviction or SSI. Any of that legal support really is important for our advocates. Let's see. I have some scenarios here that I really can't.
Okay, I did see one question earlier, and I'm not sure if you touched on it already. Can you say more about how screening for DV differs from standard agency screening?
Well, I think it's an extra. I think you have to be, trained, because standard agency screening misses DV. Until I knew that there was that overlap phenomena for physical abuse and or DV, I wouldn't have just gotten on my bench a straight physical abuse case and said, let's screen for DV. I didn't know that there was going to be a 40 to 70% overlap of DV there, and that's why she's not protective. She can't protect because she herself is being threatened. So what does it look like? It looks like having somebody with an eye, having trained people screen the cases, having people up front know what family violence looks like, having people at the who are writing reports go into trauma, go into questions that can help unpack why somebody might have been paralyzed in a certain situation where other people wouldn't have been. Why is she using so much Xanax, or why is she over-medicating? Why isn't she showing up? Why isn't he doing what he needs to be doing? I mean, I think we just need to not, I think regular screening probably everybody needs DV training to do good screening in dependency court. Because from what we know, there's a lot of family violence which isn't discovered until towards the end of the case. And if that's true, then we really haven't helped the family out, and we haven't kept the child safe. Okay, so yeah, looks like have answered most of the questions.
Yeah, so we have one more person, a couple more people typing, so we'll just give them a minute. We did have a question come in the chat box about certificates for all 3 webinars. You can request the certificates through the evaluation that will come up at the end of the webinar. There's also a link to it in the web links box if you don't get the pop-up when you leave. We are a little behind on the certificates. We'll be sending out Part 2s next week, and then Part 3 is probably by the end of the week, next week. So that is still upcoming, and we're just giving another minute for people to type. All right.
Getting a lot of thank yous, and I want to thank you all for letting me talk for an hour and a half about a topic that I love. And thank you for doing all of the work that you do. I know that if you're on this webinar, you are on the front lines. And take care of yourselves. I do a lot of yoga. I do a lot of meditation. Make sure that you're taking care of number one so that you can continue to be a resource for healing. And thank you, Alicia and CJ, for asking me to do this seminar.